From WKNOW, this is Steve Chanley with One Question Too Many. Today's program is made possible by the law firm of Employer Advocates Group, serving California employers since 2002, with offices in Orange County and San Luis Obispo County, California. eaglawgroup.com. We're joined today by Lawrence Pockers, a partner with Duane Morris in Philadelphia. Is it okay if I call you Larry?
Absolutely.
Larry represents clients in complex commercial litigation across the country. He's the co-chair of the Duane Morris Trade Secrets and Non-Compete division of its trial practice group, and he's a member of the firm's governing partners board. Thanks for joining us today, Larry.
Thanks for having me, Steve.
So how long have you been practicing law?
26 years.
Does it seem longer?
Some days it seems longer, and other days it seems like just yesterday that I was a first-year associate trying to figure out my way in the world.
How long have you been with Duane Morris?
All 26 years. I like to tell people that this is my first real job.
So your primary practice is in the area of non-competes and trade secrets. Is that right?
That's right.
Can you tell us a little bit about that?
Sure. Like most people, it's not as if as a young child I said, Mom and Dad, boy, I really always want to be a non-competed trade secrets lawyer when I grow up. I had no idea what a trade secret was, nor did I have any idea what a non-compete was. I didn't come from a family of lawyers, but I got into this practice shortly after I started here at the firms, going on one side years ago. Broadly speaking, and I'm not sure some of your audience will be familiar with non-compete trade secrets, others might not be, but generally speaking, a non-compete is a shorthand term to refer to an agreement, usually an agreement between an employer and employee, but not always, that includes restrictions on the individual's ability to keep with, in case of an employer-employee agreement, the employer for some period of time after a certain geography or with respect to certain customers. Trade secrets can be any process, formula, compilation of information that derives independent economic value from not being generally known or readily ascertainable by those who could benefit from it. So sort of the classic example of trade secret people think of is the Coca-Cola formula. Only a few people know it, and if competitors had it, they could build a better Coke, so to speak. Trade secrets don't need to be just chemical formulas, definitionless, blah, blah, this and that.
How many of your trade secrets cases these days involve algorithms?
I would say a fair number in the sense that, algorithms and other artificial intelligence in particular kind of applying a larger role in many different industries. And so I sort of differentiate between the technical trade secrets cases that involve things like that on one hand versus the softer trade secret cases, which involve customer lists, proprietary information about customers and ways of doing business on the other hand.
Was there something about this practice area that drew you in once you were exposed to it?
Yes, I would say, first of all, it's an exciting area of practice because many of my cases involve situations where there's an emergency. Typical scenario is client will call or email. We have a situation where an employee or a group of employees has just resigned and they're going to work for a competitor. I think they're doing so in violation of their non-compete agreements, or we think that they are about to use trade secret information that they learned while at the company, or both. And those types of cases frequently end up with injunction filings. People file a lawsuit and then file a motion seeking a court order that will prohibit the employee or employees, by that time we'll use ex-employees, or from doing something, whether it's competing with the company or using trade secrets, both And when you seek an injunction, a temporary restraining order or preliminary injunction, speed is the name of the game. And so you're really trying to get to court quickly. And that's sort of a mini trial. It's not the entire case itself. It's a case within a case. And so it tends to be very exciting. It tends to be sort of drop everything and work around the clock. And I don't know, I guess that fits with my personality.
Can you explain to our listeners sort of procedurally how trade secrets disputes are different than most business tort cases?
Yeah, there are a few differences. I mean, first of all, in some jurisdictions, and California is a good example of this, the plaintiff, the party bringing the lawsuit, state court and some federal courts, depending on how the judge interprets the most immediate procedural requirement for most judges of state law. Plaintiff would be required to identify its trade secrets at an early stage in the lawsuit in order to move forward with discovery. So that's a procedural difference that's different than other tort cases where the plaintiff doesn't really need to lay out its entire theory before proceeding to discovery. The other big difference is, I think, tied up in the fact that these cases tend to be injunction cases. So, the employees are stealing the Coke formula, right? You can't wait as the Coca-Cola, you can't wait for the year, 2 years down the road for trial on the merits where damages are at issue. The formula has been stolen by that. And then another big difference procedurally is because the subject matter of the lawsuit is a secret, right? It's a trade secret. Filings in court are public typically. And so a big issue in trade secret cases is maintaining the secrecy of the information that is at issue in the litigation. And that's done typically through a few different ways. One is confidentiality agreements that courts will enter if the parties can agree, sealing motions where courts will seal filings in the case, closed courtrooms where judges will hearings, not permit the public at large to be in the courtroom, and sometimes even what are known as in-camera proceedings. That means where instead of being in the courtroom, you're in the judge's chamber and the judge is looking at something that is not in open court.
I tend to view trade secrets and non-compete cases as being front-end loaded in terms of the attorney work involved.
Very front-end loaded. Yeah, I think that's fair. There are certainly trade secrets and non-compete cases that don't involve injunctions and that follows a typical path that civil litigation follows. But yeah, I think that's fair that in the majority of non-compete and trade secret cases, even those where an injunction motion is not filed, they do tend to be more front-loaded, meaning that more of the work is done earlier in the case than later in the case, which is normally the paradigm in civil litigation.
So in your practice, do you have a team of lawyers who are at the ready whenever you get that call from a client that somebody has left and they have reason to suspect they stole trade secrets and went to a competitor?
I do, and it one of the reasons why this platform at Duane Morris has really served my practice well is because geographically we're in virtually every major market in the country. And so as part of our non-compete and trade secrets group firm-wide, we have something like 75 or 80 members. Those members comprise lawyers in our trial group, but also some of the lawyers in our IP group, some of the lawyers in our employment and labor group. And those lawyers are located all throughout the country. And so most my clients' disputes, there's no rhyme or reason to where the case may end up getting filed. Most of my clients, I repeat customers, have business throughout the country. And so I'm just as likely to be in California or Texas or Illinois at any given time as I am in Pennsylvania. And so I need that team and that bench of talent, which we have, to help support my practice.
Are you sometimes required to take over a trade secrets case or non-compete case from another firm?
I am. I've got a few of those right now, as a matter of fact. And that's always an interesting experience when you're taking over a case midway, or sometimes not midway, sometimes almost right before trial. And I've had that experience as well. Most of the lawyers that I've dealt with in that circumstance, the lawyers who I'm replacing, have been very gracious about it and more than willing to help out. So the downside, of course, is that I have my own way of doing things. I expect a case to be in a certain state when it reaches the midway point, the pretrial point. And that's not always the case when you take over from another firm. But yes, that circumstance arises relatively frequently.
Do you both prosecute and defend trade secrets cases?
I do, yes. My clients are on both sides of these issues, and so that is a core part of my practice. I represent, most of the time, almost all the time, I'm hired by a company as opposed to by an individual. That company may be the ex-employer, the company filing a lawsuit, or they might file a lawsuit, or that company could be the new employer, the company getting sued, or whose employee is getting sued, or sometimes both. And so sometimes in the circumstance where I represent the new employer, sometimes I'm retained to represent both the new employer and the employee or group of employees. Sometimes I'm retained just to represent the new employer. Sometimes I'm retained just to represent the employee or employees at issue. But at any given time, I have cases where I represent the plaintiff on the one hand, and cases where I represent the defendant or defendants on the other hand.
That's been my experience as well. And I think that's one of the things that makes practicing trade secrets law so interesting, because if you do it for a while, you become very well versed on both sides of the case, which helps you out if you're prosecuting it, because you can anticipate all the defenses and vice versa. Is there something about trade secrets and non-compete cases that maybe make them a little bit more contentious than normal business tort cases?
Yeah, I think there is. And I liken these cases often to divorce cases, not business divorce cases, actual divorce cases in a family law setting. In the typical scenario, we have a company that has employed someone or a group of people for a considerable period of time. And typically the cases that land on my desk, they're cases involving an employee or employees who are really critical to the business. And so the employer and the folks left behind at the employer often feel that they've been betrayed by the employee or employees who are leaving to maybe form a new competitor, or maybe going to an existing competitor. And so I would say that one of the recurring themes in these cases is that there is emotion involved in a way that you don't see in your typical business dispute cases. And to be clear, I have many business dispute cases that have nothing to do with trade secrets or non-competes, or at most tangential relationship to trade secret and or non-compete law. And you just don't typically see that same level of emotional investment really on both sides that you see in non-compete and trade secret cases.
That's been my experience as well. Tell us about the Valspar case.
That was a great case. It was such a fun case for a great client. So the case involved an engineer who was responsible for being what was called the beverage ends unit of the business. And that was, as the name may suggest, that's literally the coating that applies to the top of your soda can or beer can. And the individual employee involved in that case had no non-compete agreement. So he did not sign any agreement containing any post-employment restrictive covenants. Let me stop for a second and define what I mean by restrictive covenants. Restrictive covenants, post-employment restrictive covenants, include non-compete provisions, but they also include other types of provisions, like provisions that prohibit the solicitation of customers or interference with customer relationships, provisions that prohibit the solicitation or hiring of employees. Those are also types of restrictive covenants, and not all agreements have all of those types of restrictive covenants. This employee has not signed an agreement containing any of those types of restrictive covenants. And so it was a very challenging case because we did seek an injunction to prohibit the employee's employment with a nascent competitor. And the theory in that case was that the employee's employment with that competitor would pose a substantial likelihood that the employee would misappropriate and use the trade secrets the employee had learned while at Valspar on behalf of the competitor. That type of injunction that literally sought to obtain a court order prohibiting the employee's employment with the competitor is difficult to get under any circumstances. Even when you have a non-compete agreement, courts don't love enjoining issuing injunction orders that effectively put someone out of work. It is especially rare in cases where there is no agreement containing a non-compete provision. We were fortunate enough to get a very good judge and develop an excellent record. And the defendant in that case, his own words and actions came back to bite him, and it ultimately led to one of those exceedingly rare injunctions of prohibiting employment of an ex-employee under circumstances where the employee had not signed any agreement containing any post-employment restrictive covenant. So I'm very proud of that case. That case really was, there's only one other case in Pennsylvania at the federal district court level where that type of relief was granted. And in the other case in Pennsylvania, the relief really was only a 2 or 3 month injunction. In our case, the injunction was much longer than that. So just an incredibly fun case for a great client and a great result.
It sounded like you were able to pull a rabbit out of the hat.
Well, it certainly wasn't a case going in where you would have bet money on getting that injunction. Let's put it that way.
And so for our listeners, that case is Valspar Corporation versus Van Kuren, and it's in the Western District of Pennsylvania. What would you say is the most momentous thing to come out of that Valspar case in the years that have followed?
The most momentous thing is that I've cited to that case many, many times before in court filings. I've cited to it in letters. And so I would say the most momentous thing is that case in particular has really helped my practice, because if you're sending a letter to an employee or counsel for an employee or a new employer or counsel for a new employer under similar circumstances, and I cite to that case, the counsel for the employee or employer is most likely going to take a look at the case, right, and see that it was my case, and see this lawyer, in addition to practicing in this area, actually has made law in this area. And so I would say that's probably the most momentous thing about that. I know certainly that case has been cited many times as well. It continues to be cited. I've been fortunate in my career to have had some terrific victories, but I'm particularly proud of that one.
That's an outstanding victory. You were discussing injunctions earlier. In a typical trade secrets case, where you have emergent situation where immediate action needs to be taken. So there's generally a flurry of activity at the beginning, gathering declarations and whatnot, going in ex parte to get a temporary restraining order, then having the court set a hearing date for a preliminary injunction and a scheduling order for expedited discovery. But all of that effort points to one critical juncture, as I see it. That's the hearing on the preliminary injunction. If you had to ballpark it, how many trade secrets or non-compete cases resolve as a result of the outcome of the hearing on the preliminary injunction?
A high percentage, because at that point, if the plaintiff gets the preliminary injunction, then sometimes the injunction itself can be so broad as to render other litigation in the case immaterial. And conversely, if no injunction is issued, sometimes the grounds on which injunctive relief are denied can really give the defendant momentum. And so in my own practice, I would say probably the majority of the time, the cases that go to a full preliminary injunction hearing where there's a decision on the preliminary injunction motion, I would say most of the time those cases do settle. Now, when do they settle? It depends. Sometimes they settle very shortly thereafter. Sometimes they'll linger for a long time thereafter. It all depends on the circumstances, including the nature of the relief granted.
And I imagine this is one of those scenarios where the heightened emotional temperature of the case might inform when the dispute resolves. Would that be accurate?
Yeah, I think that's fair. And I'm sure you've had this experience too. At some point, we're talking about business people. And even with the heightened emotions that come with these cases, at some point, the business imperatives may not fully take over, but they do enter the picture if they were not already part of the picture. And so you do have circumstances where, notwithstanding one side or both sides, just absolute sort of intention to litigate to the death, so to speak, for business reasons, the case may settle. But I think emotions rarely exit the picture altogether in these cases. I think they're always that former employer's sense of betrayal and the employees, new employers sense that they are being singled out for mistreatment relative to others who may have left the company. Those emotions don't completely go away.
So if the cases don't resolve, then ultimately you're required to try the case. How often does that happen, would you say?
It definitely happens, and it's happened many times in my career where one party or the other may have moved to injunctive relief. The case still ends up going to trial. More typically, the trade secret and non-compete cases that more typically go to trial are those where there was no motion for injunctive relief. And that sometimes happens. It happens under various circumstances. Sometimes the employer doesn't get wind of the employee having joined a competitor till much later in time, at which point, an injunction is not really a viable option. Sometimes for tactical reasons, non-compete trade secrets cases, plaintiffs don't bring motions for injunctive relief. And so those are the cases that more typically end up going to trial. But I've certainly had a couple where there have been injunction motions and the cases still went to trial.
So can you speak on this point, jury attitudes when you're trying a trade secrets or non-compete case? Because there's a tension between an individual's right of self-betterment and mobility, then that's counterbalanced by the harm caused by somebody stealing your trade secrets. Do juries wrestle with that dichotomy?
In my experience, they do. I think really the views are all over the map on this issue, in my experience, as they are on many issues. And it very much depends on individuals. It depends on, jury pools. It depends on where you are. But by and large, my experience has been that there's certainly some segment of the population, the jury pool writ large, that may have some level of hostility toward agreements that they view as being unfair. But by the same token, there's a large segment of the population that believes a reasonable agreement should be enforced. And I would say there's an even larger segment of the population that believes that when somebody makes a promise and they then act as if they never made that promise or take advantage or try to take advantage of their ex-employers in ways that are unfair, I think juries, there's a large segment of the jury pool out there, and I've seen that was not afraid to come out for the former employer in those situations. My experience, I'm a big believer and proponent of our jury system. I think jurors try to get it right and want to get it right and take pride in the fact that they are performing an important service. And so I think it is still the best way that exists to resolve disputes.
Now, you litigate cases on a nationwide basis, and you were talking about the different jury attitudes. Does that vary by geography?
It can. I tried a number of cases in Texas by way of example, and there's a pretty big difference between trying a case in East Texas in federal courthouse in Marshall, Texas, on the one hand, versus trying a case at the federal courthouse in Austin, Texas. So same state, very, very different jury pools, very different demographics, different attitudes in some ways. And that's just one example. That example exists throughout the country. All depends on where you are.
The Federal Trade Commission has been very active in this area of restrictive covenants in the last several years. How has that impacted your practice?
Well, I was pretty busy last year after the FTC. So for those who aren't familiar, the Federal Trade Commission consists of 5 commissioners and their political appointees. And so when the president at the time, the party in power, typically 3 of the 5 commissioners are appointed by that party, and the other 2 by the party that's out of power. And it obviously reverses if the White House change in stance from one party to the other. But the FTC voted 3-2 last April to approve a non-compete ban that the FTC had first proposed in January of 2023. And the ban was scheduled to go into effect in early September of 2024. And that the ban would have made illegal virtually all non-competes, both prospectively and retroactively. There was an exception for existing non-competes with senior executives. And so the regulations that accompanied the ban required companies to actually send a disclosure to their employees and others who may still be bound under non-compete clauses, advising those individuals that their non-compete clauses were no longer enforceable, were void, would not be enforced by the company. So those notices all had to be sent out before the ban took effect. They were supposed to be plated before the ban took effect. The ban was scheduled to take effect, I think it was the Wednesday after Labor Day. And so there were court challenges to the ban, including a case in Texas that was filed by the Chamber of Commerce and a couple other litigants, and then a separate case in Texas that was filed by a tax preparation service. Those cases were consolidated in the Northern District of Texas. And the judge in that case waited until the very end, decided on competing motions for summary judgment about a week and a half before the ban was scheduled to take effect, and issued an order that set aside the ban for all, not just the litigants in the case. And so for many of my clients, I was last summer extraordinarily busy getting those notices ready for companies that I represented that were getting ready to notify all of their employees or former employees who had agreements containing non-compete clauses, that those non-compete clauses were not going to be enforced, that were unenforceable. When the court issued its order in the Northern District of Texas setting aside the ban, those everyone sort of breathed a sigh of relief. It's not over yet. That case in the Northern District of Texas and another one that was in a federal district court in Florida are up on appeal. But now that the administration has changed over, there's the Republican majority of the FTC, the acting chair, Andrew Ferguson, who was in the minority in the last administration, had dissented from the ban. And so he's done 2 things. First, he's impaneled a task force to look at unfair methods of competition, and included in that are unfair non-compete agreements. So he's tasked various bureaus within the FTC to come back and make recommendations. At the same time, the FTC has moved for a 120-day stay of the appeals of the Texas case and the Florida case. And so it looks as if, as of this taping, it looks as if the FTC will likely not pursue those appeals while the FTC determines how it wants to treat non-compete agreements going forward. If I had to guess, my guess is that the task force that the FTC chair has impaneled will come back with certain recommendations, probably recommendations relating to non-compete clauses between companies and lower wage employees. That would be consistent with what many states have have legislated in that area specific to lower wage earners. And I could see, the FTC getting behind a new rule that might single out those types of non-compete clauses. But I think in all likelihood that the notion of an across-the-board ban that would apply both to, the CEO and an agreement with the proverbial janitor, I think that's probably going into the dustbin of history with this new FTC majority.
I'm going to switch gears here a little bit. Are you now incorporating artificial intelligence into your practice?
To a degree, and let me explain what we're doing here. There are a couple of materials on this about giving away any trade secrets in saying this. We have a tool it's not a proprietary tool. Partnered with one of the companies that's offering an AI tool to law firms. We're part of our pilot program for that tool. I've tested it out. I'm actually in the pilot group. It's pretty powerful. I have to tell you, it's pretty interesting to contemplate being able to use a tool to, by way of example, summarize a contract that might have taken 2 hours to summarize, could take a matter of 30 seconds to summarize. The issue, at least as I've seen it in practice, is that those tools, they are still far from perfect. And you need to check the work and need to make sure that, you're not solely relying, an AI tool. And so I think ultimately my own personal view is that AI will supplement the practice of law. A lot of people out there are suggesting that, we're going to have robots take our places as lawyers. I don't see that happening. I think that it will be a supplement. I think that there will be certain tasks that AI will be able to perform in a way that's just way more cost effective for clients. We're seeing, clients are asking about it, demanding the use of AI in many cases. So that's I
agree with you also that ultimately AI is going to prove just to be a tool that augments human thinking and will not supplant human thinking. And I don't think it's being designed to do that, but we're still sort of in the nascent stages of how it's actually deployed in industry. And so there's a lot of questions surrounding it, but it's interesting to get the opinions of various attorneys and how they're incorporating it into their own practice. And the key thing that I hear all the time is just the efficiencies that result from using the AI, and that benefits the client and ultimately frees the attorney up to do other tasks that can't be done by AI.
Agree 100%. That's been my experience as well, and that's my prediction for sort of how things play out. Yeah.
Can you tell us about your pro bono and volunteer work? That's something that I really think distinguishes you from a lot of attorneys.
I appreciate you saying that, and yes, I always love talking about that aspect of my practice and the pro bono side and my volunteer activities. Some of that, by the way, overlaps, and I'll tell you what I mean by that. On the pro bono side, much of my pro bono work has been on behalf of an organization based in Philadelphia here called the Support Center for Child Advocates. The Support Center sort of fills the void in the criminal justice system and the Department of Health and Human Services system that exists where no one's representing the children. And so the Support Center exists to match volunteer attorneys with kids who are caught up in the system, whether because their parents have been adjudicated in criminal court or there has been Real City's Department of Human Services has got involved because of an issue that's with one or both parents. And so I'm really proud of the work that I've done over the years for the organization. I was honored to was one of their distinguished advocates. 2013. That dovetails with some of my volunteer activities because I was on a volunteer committee for the Support Center for many years. Eventually, they asked me to joined their board of directors. I've sat on their board of directors for the last 2 or 3 years. I also volunteer for the American Red Cross, particularly the Southeastern Pennsylvania region chapter of the American Red Cross. Did both a volunteer and a board member for that organization, first on the blood services side, and then on combined board provides all of the various services and offerings of the Red Cross for the last several years. I'm actually the chair of that board. I've been chair for a term now, going on years. So those are 2 organizations that I've spent a lot of time volunteering for. They're organizations that are near and dear to my heart because of the missions of those organizations. And so I'm with you. I think we're so lucky. I consider myself incredibly lucky and blessed to be able to practice law, to have a great practice, to make a very good living, to be able to give back. I didn't grow up with any money. I could have seen myself then, where I am now. I like to think that I'm proud and they've things because they're important.
Is pro bono work and volunteer work something that you encourage young attorneys in your firm to do?
Absolutely. We see our money where our mouth is too, because we actually we have, as with many big firms, have billable hour vacation for our associates in particular. We devote a certain portion of those billable hour expectations to pro bono, meaning that we can satisfy that expectation by doing pro bono work up to a certain number of hours. And so, we do that. We also encourage our associates to do pro bono because it's the right thing. We encourage all of our lawyers pro bono, have a whole pro bono team. That's very proud of the fact that we have such a high percentage of our lawyers do pro bono. It's not only the right thing to do, but I always encourage younger lawyers to pro bono also because it's a great opportunity to get real experience that sometimes associates don't always have the opportunity. So, in the good example is our trial associates. They may not be trying a case in federal court or they're at first chair as a second year or third year. But I'll tell you what, we've had many of our trial associates who have done that in pro bono cases. And so it's a phenomenal opportunity to gain experience as well as, doing the right thing.
So now I've come to that point in the show where I have to ask you the proverbial question. Have you ever asked that one question too many?
I thought you would probably ask me that question since it is the name of the show. I am sure that I have, and I racked my brain to think of a good example coming into this taping. I was unable to think of a good example, but I am sure, I know I have had the feeling in my career where I'm questioning a witness and right after it comes out of my mouth, I have that queasy feeling of, oh, no, I should not have asked that question. And, you can see the witness sort of perking up because I've thrown out there, that red meat for the witness. So I can't think of a particular example, but the answer is yes, I've done it. I think probably every trial lawyer has done it. You learn from it. I don't think I've done it in the last, 10 or 15 years, but certainly earlier in my career, I did it and you never forget that feeling. You may forget the details as I have, but you don't forget that queasy feeling of, no, I asked one question too many.
Larry, I thank you for joining us today. Can you let our listeners know how to get a hold of you?
Sure. Larry Pockers, Pockers. I'm at Duane Morris, DuaneMorris. We're a 900 lawyer firm based here in Philadelphia. This is our mothership. You can find me on the web, of course, at DuaneMorris.com. My email's lhpockers@DuaneMorris.com. And I think that's probably all the contact information that your audience can stomach.
Thanks again for joining us.
Absolutely. Thanks for having me, Steve.